Case 76, Hawaiian Airlines versus Norris. We find ourselves here at the Supreme Court of the United States. Facts. Respondent Norris was terminated from his job as an aircraft mechanic by petitioner Hawaiian Airlines after refusing to sign a maintenance record as required by his collective bargaining agreement for a plane he considered unsafe and reporting his concerns to the FAA. In separate state court suits against Hawaiian Airlines and its officers, also petitioners, he alleged, among other things, that he had been wrongfully discharged in violation of the public policy expressed in the Federal Aviation Act and implementing regulations and in violation of Hawaii's Whistleblower Protection Act. The court dismissed these tort claims as preempted by the Railway Labor Act's mandatory arbitral mechanism for so-called minor disputes, which grow out of grievances or out of the interpretation and application of agreements concerning pay rates, rules, or working conditions. The state Supreme Court reversed, concluding that Section 153, plain language, does not support preemption of disputes independent of a labor agreement, and interpreting the opinion in Consolidated Rail to limit RLA preemption to disputes involving contractually defined rights. The court rejected petitioner's argument that the claims were preempted because resort to the CBA was necessary to determine whether Norris was discharged for insubordination, pointing to Lingle, in which this court held that the Labor Management Relations Act preempts state law only if state law claim is dependent on the interpretation of a CBA, and that purely factual questions about an employee's conduct and the employer's conduct and motives do not require interpreting such an agreement's terms. So what's the issue? Whether the RLA preempts Norris's state law causes of action. The court held that the RLA does not preempt Norris's state law causes of action. Let's look into the reasoning. Collective bargaining refers to negotiations between an employer and the representatives of organized employees to determine the conditions of employment, such as wages, hours, and fringe benefits. A collective bargaining agreement is a contract that is made between an employee and a labor union and that regulates employment conditions. In Norris, an airplane mechanic was hired by Hawaiian Airlines. Many of the terms of his employment were governed by a collective bargaining agreement negotiated between the carrier and the International Association of Machinists and Aerospace Workers. Under the CBA, respondents' duties included inspecting and repairing all parts of a plane and its engine. On July 15, 1987, during a routine pre-flight inspection of a DC-9 plane, he noticed that one of the tires was worn. When he removed the wheel, respondent discovered that the axle sleeve, which should have been mirror smooth, was scarred and grooved. This damaged sleeve could cause the landing gear to fail. Congress's purpose in passing the RLA was to promote stability in labor management relations by providing a comprehensive framework for resolving labor disputes. To realize this goal, the RLA establishes a mandatory arbitral mechanism for the prompt and orderly settlement of two classes of disputes. It was enacted in 1926 and extended to airlines in 1936. The first class of disputes concerns rates of pay, rules, or working conditions, and are deemed major disputes. Major disputes relate to the formation of collective bargaining agreements or efforts to secure them. The second class of disputes, known as minor disputes, grow out of the grievances or out of the interpretation or application of agreements covering rates of pay, rules, or working conditions. Minor disputes involve controversies over the meaning of an existing collective bargaining agreement in a particular fact situation. Thus, major disputes seek to create contractual rights and minor disputes to enforce them. The court has held that the RLA's mechanism for resolving minor disputes does not preempt causes of action to enforce rights that are independent of the CBA. Here, the CBA is not the only source of Norris's right not to be discharged wrongfully. In fact, the only source of the right Norris asserts in this action is state tort law. Wholly apart from any provision of the CBA, the airline had a state law obligation not to fire respondents in violation of public policy or in retaliation for whistleblowing. The parties' obligation under the RLA to arbitrate disputes arising out of the application or interpretation of the CBA did not relieve the airline of this duty.